Today, we will briefly discuss the role that trusts play in effective estate planning. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the great states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level, and I hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Estate planning is a crucial aspect of financial management and wealth preservation, and the role of trusts within this framework cannot be overstated. Trusts are versatile legal instruments that can offer significant benefits in terms of asset protection, tax efficiency, and control over the distribution of your assets and estate. As a tax attorney and CPA, I have seen firsthand how the strategic use of trusts can transform an estate plan for the better. This brief video explores the various roles that trusts can play in estate planning. One of the primary functions of a trust is asset protection. By transferring assets into a special type of trust, individuals can potentially shield their wealth and assets from potential creditors and legal claims. This is particularly beneficial for individuals in high risk professions who may face the threat of litigation. Assets held in an irrevocable trust, not to be confused with a revocable trust, which is different. Assets held in an irrevocable trust are generally not considered to be part of the grantor's estate, thus potentially offering protection from creditors. Moreover, trusts can safeguard assets for the benefit of beneficiaries, ensuring that they are protected from third party claims, divorce settlements, or poor financial decision making. This level of protection can provide peace of mind, knowing that your wealth will be preserved for future generations. Trusts can also be powerful tools for minimizing estate and gift taxes. Certain types of trusts, such as irrevocable life insurance trusts, among many others, can remove taxable value, for example, life insurance proceeds, from the taxable estate. This effectively reduces the overall estate tax liability. Additionally, grantor retained annuity trusts, sometimes referred to as GRATs, and charitable remainder trusts offer opportunities to transfer assets out of the estate, thereby potentially further reducing the taxable estate value. Furthermore, trusts can, when structured correctly, let me back up. Trusts, when structured correctly, can provide income tax benefits. For instance, income generating assets placed in a trust can potentially be taxed at the trust's tax rate, which may be different than the individual's rate. This strategic tax planning can result in significant savings over time, enhancing the overall efficiency of the estate plan. Trusts offer unparalleled control over how and when assets are to be distributed to beneficiaries. This is particularly useful and applicable when planning for minor children or beneficiaries who may not be financially savvy. Trusts can stipulate conditions for distribution, such as the attainment of a certain age or achieving specified milestones, such as graduating from a university, which helps ensure that the assets are more likely to be used responsibly. Additionally, trusts can be structured to provide for special needs beneficiaries without jeopardizing their eligibility for state and federal government benefits. This ensures that loved ones with special needs can be cared for in a manner that enhances their quality of life while preserving their dignity and financial security. Another significant advantage of the application and utilization of trusts is their ability to bypass the probate process, which can be lengthy, costly, and public. Now, to be clear, merely having a trust is not, let me say that again, not sufficient to avoid probate. Certainly, having a trust is the first step, but there are many other steps and processes that must be assiduously observed in order to minimize, if not outright eliminate, the cumbersome probate process. Assets held in a trust are not subject to probate, allowing for a more streamlined and confidential transfer of wealth to beneficiaries. This privacy can be particularly appealing for individuals who value discretion and desire to keep their financial affairs out of the public eye. The avoidance of probate also means that beneficiaries can access their inheritance more quickly without the costs and delays often associated with court proceedings. This can be crucial in situations where timely access to liquidity is necessary to cover expenses or debts. Trusts offer a level of flexibility and adaptability that is unmatched by other estate planning devices, such as wills. For example, a revocable living trust can be amended or revoked entirely by the grantor during his or her lifetime, thereby allowing for adjustments and amendments to the estate plan as life and financial circumstances change. This flexibility is invaluable in accommodating life events such as marriage, divorce, a windfall, or the birth of a child. Additionally, trusts can be strictly tailored to meet specific goals and objectives, whether it's providing for educational expenses, supporting charitable causes, or ensuring the smooth transition of a family business. This adaptability and versatility makes trusts a valuable component of any comprehensive estate plan. In conclusion, trusts are a vital and indispensable component of effective estate planning, offering numerous benefits that extend far beyond the mere avoidance of probate. From an asset protection standpoint to tax efficiency and control over distribution, trusts provide a level of security and confidence that is hard to achieve through other means. As you consider your multi state estate planning needs, consulting with a qualified tax attorney and CPA can help you determine how best to incorporate one or more trusts into your holistic strategy. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, L-A-W, www.cummings.law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.